The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barquette, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn. Substituting in today for Dan Grimm is my law partner, Jacob Lawrence. Jacob, say hello to everyone today.
Hey, everybody. Thanks, Matt, for having me on again.
Oh, wouldn't have it any other way. I mean, trying to keep you from here. That's like a weekly struggle to keep Jacob off the radio. I mean, it's where you belong.
Here we are.
Here we are. And today, because it's Jacob and myself, we're going to talk about our firm's trial history. Because in our immediate trial history, Jacob and I have tried the 3 cases that have gone to trial since COVID. Should point out, just prior to COVID, Mike Ponder took one to trial, and well, there was an 8-figure recovery in that one that later settled for a confidential amount. So yeah, all of us are capable of going to trial. It just so happens the last 3 have been really down to Jacob and I, so which is fun work.
Absolutely.
Yeah. Well, I remember when we recruited Jacob to come here. Jacob was a graduate of Southeast Missouri State University. He had pitched for them on their baseball team. He played, I think, 1 season of professional baseball. And then the lure of law school just got to be too much. I mean, he just couldn't resist. And off to Mizzou he went. When I was selling him on our firm, I gave him the same sales pitch that I tell people that I meet in Cape Girardeau and in Southeast Missouri. And that is, if you're going to go to a plaintiff's firm for representation or to work there, you want to go to a firm that, first of all, can say no to cases. You don't want to work at a firm or be represented by a firm that is trying to turn every little tiny injury into $1, right? We don't have time for that. If you're not really injured, go handle your own claim. Number 2, work at a firm that'll try cases. Taking a case to trial is one of the most complicated endeavors any law firm can engage in. And we have an entire team. We have 3 lawyers in our office now that don't take cases to trial. They actually only provide support to the 4 of us that do take cases to trial. And that's huge. We're willing to spend that kind of money on the personnel we need in order to get your case in front of a jury. And not only spend the money on the personnel, but also on the experts, on the doctor's depositions, on all of the evidence that we're going to need to present your case in such a way. And I hope, Jacob, that we were honest with you when we were telling you that way back when.
Oh, absolutely. I've seen it in other plaintiffs' firms who, the first part of that you mentioned, it can't turn down cases. And, sometimes that's a financial thing where someone comes in the door and that firm, they just have to take everyone they can because, they got to take what they can get. And you're absolutely right. Fortunate to be in a place where we don't have to do that. We don't have to take every case that comes in. And then towards the second part of what you're talking about there, the support staff through the trial is absolutely key. You can't do that on your own. And we're fortunate again to have the 3 that you mentioned that helps us get there.
Oh, absolutely. I mean, in both cases that you and I recently tried, you first chaired one of them, I first chaired the other. But Kathy Woles was there for all 3 days at both of our trials, and was there to answer any legal question that cropped up that might be unusual, something that doesn't come up very often, something that she's learned over her 30-plus years experience in doing this job. That is just invaluable assistance.
Oh, no doubt. Specifically in the recent one we had a motion for a directed verdict with an unexpected issue, and Kathy was on the ball, found the case law that we needed right there, right on the spot. And that was huge. That's a difference maker in a trial. Another large part of what she does is the jury instructions.
Yes. That is not to talk too deep into the shop, but that is the number one way to get your verdict, your great result, your wonderful recovery at trial. To get that overturned on appeal is to do the wrong jury instructions. And the judge I had in my case that we'll talk about actually calls Kathy the guru of instructions for Missouri civil cases. So she is one of the best lawyers in the state of Missouri on those instructions, and that makes a huge difference.
Yeah, no doubt.
Because that's not anything I want to mess with.
It's tricky, and like you said, there's a lot of downside if you mess it up.
Yeah. Yeah. Well, let's talk briefly then about our most recent one, a case that involved a low water bridge. When did that case come in, Jake?
This was late 2018 when the case first came in.
Okay.
Shortly after the incident occurred.
Okay.
The situation was father driving his sons in the vehicle, and in a rural area. It's a rainy day. They approach a low water bridge. This is the type of bridge where water is designed to go over the top of it, you know. And there's no rails on it, you know. Pretty short and narrow bridge. Anyway, there's water going over the top, and the father is unable to accurately judge how deep the water is. Drives into it. That's when the incident happens. The water sweeps the vehicle into the river. And unfortunately, the boys' lives were lost.
Yeah. And so it was Mom who came into our office to meet with you. Unfortunately, it's all too common. We're dealing with a parent who's lost a child, or a husband who's lost a spouse, or a parent, and those are heart-wrenching meetings. And you have to act not only as legal advisor but as counselor to some degree.
Yeah, no doubt. I mean, these people have been through a large trauma, and especially in this scenario where the mother wasn't there at the scene.
Right.
You know, she wasn't involved. She wasn't in the vehicle. So it's situation where, you know, she's at work and she gets the phone call and notifying her of what happened.
Yeah. And when she's there in our office the first time, I mean, understandably, people look for answers. They want to look for somebody to blame for this. And, you know, what were her thoughts initially on her case?
Well, you know, initially it was probably the same reaction any of us would have had is, what was that driver doing? You know, why would he enter a roadway like that? And of course, at that time, you know, like you said, you're so blinded by all the emotion that you have going on and the trauma that just happened. So, you know, that was her initial reaction, was why would he ever do something like that?
Right.
Not taking into account any other avenues that could possibly be a cause of the incident.
Right, and that's why you go to an attorney, because very early on in the process, who did you start to look at as a potential defendant in the case?
Well, we took a look at the roadway and the condition of the roadway and the bridge itself, and immediate defects were obvious.
Right.
And so that was the avenue then that we uncovered and pursued in that particular case.
Right. And so when you're gonna sue the entity that owns and operates or maintains that road, you're going to have to allege it's defective. Now, our clients aren't going to ever look at a bridge and have the expertise to say it's defective. We don't have that expertise. We have the legal expertise to know that probably something is wrong with it, but we have to find somebody to help us navigate those waters. So who did you reach out to?
Yeah, so we used a engineer, Ben Hozinski is his name, out of Indianapolis, and he's a civil engineer, has worked on bridges like this, designed bridges specifically like this, and he was a great resource to get involved, especially early on, to help, like you said, guide us through and educate us on specific things that are wrong with the bridge. Some of the things were more obvious than others, and he was able to uncover a lot. And also he was able to instruct us and educate us on how to properly build and maintain this specific type of structure.
Right. And so when you consult with an engineer like that, I mean, obviously we have to pay them for their time, and that's money that our firm pays. If we were to lose this case, we will lose that money. It will be part of our cost of doing business. Our clients will never pay for their experts unless they win and then they get money, then it can come out of their portion. But our clients are not going to have to write a check to our firm to cover the expert costs.
Right.
We're going to cover that up front. And so the expert tells you that, hey, this might actually be the fault of the person maintaining the bridge. You know, how did the client react when she heard that?
Well, I think she was surprised, you know. I mean, it hadn't occurred to her that could be a possibility.
Right.
But then, you know, the key is the engineer came and did a scene visit for himself, took measurements, you know, and really did an evaluation and a personal inspection. So when I was, you know, after that happened, I was able to present to the client, look, this is what he found. These are the photos he took. So I was kind of able to educate her, and you know, then she realized that was another possible claim that she hadn't thought of before.
Right. So that gets you part of the way around the bases. You've got a liability expert to talk about the defects in the bridge. and then you've got to also talk a bit about damages. And this was a drowning case, and I thought really in particular you were really creative in the damage part of this. Tell the folks who you talked to for that part of it.
Yeah, we brought in a forensic pathologist who's a doctor who is for a long time a forensic medical examiner, coroner, has done that throughout a career and has investigated, unfortunately, scenes and incidents just like this. And she was a fantastic witness who was able to come in to describe the damages, the things that the boys went through, and ultimately established causation of the death in regards to the incident.
Yeah, I mean, I recall that being very powerful testimony. So that's a snapshot in how Jacob got his case ready for trial. In the second half, we're going to talk about both of our actual trials. The other case we tried was a case involving a rocking chair that my client was sitting in, and he leaned back in it, and it snapped in two. Now, that really shouldn't happen. A rocking chair really ought to hold you up. But the question was why? And in this particular case, within 72 hours of the incident, the owner of the chair threw the chair away. And we couldn't inspect it. We couldn't take a look at it. It was gone. It was gone before my client ever contacted any type of representation. And so we're trying to make an allegation that there's a defect in this chair and that it somehow failed because of some negligence on the part of the chair owner, but we don't have the chair. Well, that's where a Kathy or a Matt Davis or a Kim Price becomes extremely valuable. There's something in the law called spoliation. If a defendant throws away evidence or spoils the evidence, then they're potentially subject to an adverse inference at trial. All right, a lot of big words. What do I mean by that? Well, I was able to argue to the judge, well, Kathy was able to argue that they shouldn't have destroyed, they had a duty to maintain this chair, and that had we been able to look at the chair, we might have seen that there's a weight limit on it. We might have seen that there was some defects in the way the spindles were glued into the base of the chair. We might have been able to see that there was some wear in there, that it wouldn't be as sturdy as it should be. We could have figured out who the manufacturer was. We could have figured out if there'd been a recall of this chair. We could have figured out if the manufacturer had, issued any warnings about how the chair should be used. We weren't able to figure any of that out. So we were able to present to the jury an adverse inference basically saying that the chair's not available. If it were available, it would show something unfavorable to the defendant. So the jury is allowed to presume that if the chair had been available, we would have gotten some evidence out there that would have hurt the defendant's case, would have helped our case. That was the single biggest victory we had in the discovery phase of that trial.
Yeah.
And it was a big one.
Do you see spoliation very often?
You don't see it much at all.
Yeah.
I would say that if you own a small business out there and you have customers who come in, I would talk to your attorney about what you do with the videotape. After an incident like that. I represented a gas station chain up in St. Louis when I was on my defense side, and I advised them, and they later adopted this. They kept every videotape from every angle after a slip and fall for the hour before and the hour after, even if it didn't show anything. And so I could tell the other side, everyone who bought gas at that gas station, or at least the cars that did, by their license plates, throughout the entire hour before and after the incident. The more evidence you can gather as a defendant, the better off you are. And I would tell my clients on the defense side that usually they're pretty good about it. But we do see spoliation from time to time. We do see defendants throwing away videotape. We see them altering videotapes sometimes, not on purpose, but by the way they save and archive their stuff.
Vehicle preservation.
Vehicle preservation, yeah, that's a big one. That the vehicles get fixed or they get towed away and put in impound and never used again. So it is a powerful tool. It's one that that I was really proud that we were able to make that argument. It's a complex argument. You need a Kathy. You need a Matt Davis. You need a Kim Price to be able to make an argument like that. So that is a bit how we get to trial. That is segment one of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Jacob Lawrence, I'm Matt Glenn. We'll be back in a few moments.
Cook, Barquette, Ponder, and Wolz are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And we're back for segment 2 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. Sitting in today for Dan Grimm is Jacob Lawrence. Jacob, how you doing this morning?
Doing great. Thanks for having me.
Wouldn't have it any other way. We've been talking in the first half about how we get a case to trial. Jacob and I have tried 2 cases together in the last year and a half, and we talked a little bit about hiring of experts and taking of depositions and everything you do, it takes to get a case ready for trial, because honestly, you've got to build your evidence. When it comes in, you talked about how your case came in looking one way, and by the time you got to trial, it looked very, very different.
Oh yeah, no doubt. In fact, different parties at trial.
That's right. Yeah, I mean, no longer was Dad a party, for a couple of reasons. But yeah, where it looked like you were going to go to trial suing both a driver and a bridge, by the time you got to trial, you were only suing a bridge.
That's right. That's right. So in Missouri, a situation like that, the standard is caused or contributed to cause.
Right.
We've talked about this a lot, maybe a basic concept. But when you have a situation like that with multiple potential parties who are at fault in an incident, if one of them contributed to the incident, then Missouri law says they're on the hook for it.
Yeah, and they have to pay for what they're responsible, and a lot of times you have to hold them accountable at trial.
And to be clear, sometimes there are credits and things like that to the other defendant. The judge takes care of that.
Correct.
That's an area for the judge to take care of afterwards. So. Anyway.
Yeah, no, I mean, you're right. And that's an important thing for our listeners to note. If you get called for jury duty, it's not your job to determine who pays what. It's only your job to determine, is one of the defendants responsible? If so, what percentage are they responsible? And how much is the value of the injury? The judge will then do the calculation. The Court of Appeals will sometimes get involved in that calculation. The trial itself is not about who pays what. The trial itself is only about what is the value of the injury and what percentage of that value is this defendant responsible for.
Yes, absolutely. Yeah. I think a lot of people don't realize that. It's huge.
They don't. Yeah. So both of us now, having been through recently the joy that is trial prep, give our listeners a little bit of an idea of what it looks like the month leading into trial.
Well, when you get about a month away from trial, a lot of groundwork, first of all, has been laid. Many times for a year or multiple years. Could be 2 years from the time that the lawsuit is filed until you get within a month of trial. 2 years, 3 years, could be more.
Yeah.
And so, a month from trial, a lot of that groundwork's been laid through the discovery process. We've talked about that some. You've got a lot of your evidence at that point. You've probably done some depositions at that point as well, but you probably still have more to do. And when you get a month out, you're looking at, if you haven't done any of your experts' depositions, either yours or the opposing side's experts, you're going to get those done fairly quickly if you're a month from trial. You can get those done.
Well, you wait a lot of times until right before trial, because those are the most expensive depositions. Those are the $5,000 deposition, maybe sometimes $10,000. And to get those taken, you've got to pay the expert.
Yes.
You don't want to do that until you absolutely have to. And if a case is gonna settle, you'd rather avoid that charge. But yeah, during that last month, you're tying up the deposition loose ends. In our office, we're filing a lot of paperwork with the court. We're arguing with the court. Kathy is usually arguing with the judge and the other side about what evidence is allowed to come in, what evidence is not allowed to come in. A lot of that gets sorted out before the jury even walks in.
Yes. Yeah. So we have the pre-trial conference, which is a hearing between both sides and the judge. No witnesses, no evidence is put on during that hearing. There's no jury there, of course.
Right.
But basically, it gives both sides the opportunity to alert the judge to evidentiary issues that they think are going to come up and get preliminary rulings on those things. So that way the trial goes smooth and the jury doesn't hear about evidence which is not allowed into court.
Right. Yeah. A lot of times a question, if asked, will alert the jury as to what the answer probably would be. So a lot of times we're prevented from even asking certain questions, like, did you have liability insurance? We can't ask a defendant that, even though by law they're required to have it. If we ask that question, that's grounds for a mistrial. We have the trial, postponed, and we have to come back and try it another day later. So.
Yeah, so again, you're looking at the month before trial, typically the pretrial conference, from what I've seen, is 2 weeks, could be 3 weeks before trial. That gives the parties then, some time after that hearing before the trial begins to get their ducks in a row.
Yeah.
And so the pretrial conference can't be understated. I mean, it's a huge part of it, and again, goes back to having the importance of having someone like Kathy or that support team to help you get through that.
Yeah, absolutely. I mean, a lot of cases are won and lost in the pretrial phase.
Absolutely.
And if you don't get the correct ruling heading into court, many times you're really stacked against it. Yeah. So that is important.
Another thing that's that has been important when you're looking at that month before trial is you got to get your subpoenas out.
Yeah.
You got to notify the witnesses you're going to call. You got to get them served, and you got to do that ahead of time to coordinate everything. You get one chance when you get to trial. You get one chance. Yeah. So you got to be ahead of the curve there and get your subpoenas out to the witnesses to make sure they're there and are able to participate at your one chance.
Yeah. Yeah. File your business records and affidavits along with those to have those available at the court so you can read them if you need to. That lays a foundation for everything. Working with the other side to overcome, the final issues that you can't agree on, and then arguing about the ones you can't. And then it's a lot of sleepless nights. I mean, it's a 2-year-long process to build a file. And the last 2 to 3 weeks, I know I'm in a dark room with one solid light on my depositions, reading and taking notes, reading and pulling things out of the testimony that I may have forgotten were in there that I want to be sure to highlight at trial. And it's through that process, for me anyway, that I'm trying to gather all the evidence I know I have and then work back out from that. Okay, what are my themes? What are the things I need to hammer home? How do I lose sight of the trees and get the forest, right? Because you got to see the big picture. You got to understand that you got to learn this case so well that you know every minute detail, and then have to figure out how do I best teach someone who knows nothing about this, absolutely nothing. How do I teach them? How do I educate them as to what my best case is? Taking for granted that they know nothing about the case. I mean, that's what the jurors do. They come in, they know nothing. You have to start with the most basic fundamental principles. And that's hard when you know a file so well because you've been with it for 2 years. It's really hard. And it's one of the more valuable things you gave me in my rocking chair case was that you were suddenly brand new to the case. And I got to bounce everything off of you. And you would ask questions of me, and I would think, okay, I've got to answer that question. I've got to make sure the jury doesn't have that same question you have.
Absolutely.
Yeah.
Oh, it's a completely different perspective. You're, as you've mentioned, in the weeds and in the details for the 2 years.
Yeah.
And then you got to present it to people who this is their first time ever hearing about this happening, and it is very difficult to communicate that sometimes.
Yeah. Well, it's a trick, and it's what we try to teach each other to do, and why we go to trial seminars every year to try to get better at this. We're constantly looking at better ways to get this done.
Another thing, when you're looking at the last month, sometimes a focus group is a great thing to do.
Yeah.
We did that in the Low Water Bridge case, and that was it really helped shape those themes and how to communicate what issues were most important to the jury to get an understanding from what jurors are going to be thinking about the case as it unfolds.
Yeah. So Jacob, a couple weeks before his trial, he brought in how many was it? 8, 10?
I think we had 10 or 12. Yeah.
10 or 12 people. Put them in a room, presented both sides of the case. And then how did it go from there?
It was fascinating. Some of the issues that we thought were going to be most important in the case, that panel agreed with us on. That's a really important fact, for instance, or this is a really important piece of evidence. But then they, of course, also added things that we hadn't thought of.
Right.
And a lot of them, in this particular case in the rural area, a lot of people have encountered these low water bridges with water going over them themselves.
Right.
And so it was really interesting to get to talk with those people before trial, before the pressure's on, and before it's a done deal to get that perspective.
Right. Well, and that is, as much as we pride ourselves on having a firm that asks a lot of questions and seeks a lot of opinions from a diverse array of people, you can never have too many opinions on your case.
Yeah, absolutely.
Yeah. I mean, there are people out there that have different life experiences that will view your situation differently because of those life experiences. Doesn't make them right, doesn't make them wrong, but it makes them important for you to know about.
Yes.
Focus group is one way we do that. We have other methods that we won't get into too much detail on, so we avoid the weeds. But, firms will hire jury consultants. We have in the past who will help us. Yeah, I've never seen Bull. I've never seen that show, but I understand that's the sort of thing he does. I'm quite sure our people do it very differently than he does. But
he makes it look so easy.
Yeah, right. I mean, yeah, he can just look at someone and knows what they're thinking. But that's not how life works. But that's one of the services we provide. We'll talk to experts, or we'll spend the money it takes to get a focus group in. Just to get a fresh set of eyes on your case so that you can learn about it.
Yes, absolutely. That's key.
So, yeah. When we get to trial, I remember the first part of mine, that's always voir dire. That's where you stand up, and I gave everybody, in my voir dire, I gave them the pie eating contest. I think you might have too. Did you use the same thing?
I did.
Yeah. And so we never reinvent the wheel. I stole it from somebody else. Jacob merely borrowed it from me. But basically, what being selected for a jury means is we try to choose the 12 to 14 most qualified jurors, and those are the jurors that we think can be the most fair. The analogy we used was, if somebody selected me to be a judge of a pie eating contest, and there were 2 pies in the final, and I'm going to go up and I'm going to pick the best one, and one of them is a cherry pie, and one of them is a coconut cream pie, wouldn't it be fair for me to say, hey, just so you know, I can't stand the taste of coconut cream pie. That is not I don't want to eat coconut. I've never liked coconut cream pie. I'll do my best to judge it fairly. I'll do my best to be fair to it. But isn't it the right thing for me to do to tell the people who bake those pies, hey, by the way, I hate coconut cream pie? And that's what we're asking during the voir dire process. That's really what we're asking of our potential jurors, is that if there's some reason you think you might not want to apply the law correctly in this case, tell us now before you swear an oath that you're going to, and then go back in the jury room and feel a temptation to violate that oath.
Yeah, at the end of the day, both parties at trial deserve an unbiased jury, and that's what it's all about. And a lot of nations have really moved away from jury trials because of concerns about bias on the jury. So it's a real concern.
Yeah, to me, it's a market-based principle. To me, I don't think there's anything more capitalistic than getting 12 people from our community to evaluate a dispute between 2 people in our community, and have those people, we pick them out of 93 so we can get some that don't have particular biases, and have them come in and sit down and listen to all the evidence. Listen to all of it and say, okay, yes, defendant, you're responsible. No, defendant, you're not. And here's how much the case is worth. I mean, that is the market at work. And I can't think of anything more fair than that.
Yeah, you're right. Absolutely. One thing you mentioned that I was going to touch on was the fact that, you didn't like coconut cream pie. It also, wouldn't be fair for you to sit on that pie eating contest and overcompensate for not liking the coconut cream pie, right?
No.
So we encounter that too on the jury bias.
Yeah.
At times.
Well, at times you certainly see people who are trying a little bit too hard to be one side or the other. You really just want them to listen, keep an open mind, and then at the end do what they do. A trial is like what many of you have seen. We put on witnesses, we give opening and closing statements. It's pretty standard. We like to think we do it very well in our office. Jacob, share with the folks what result you got.
Well, we had a $2 million jury verdict in that low water bridge case.
Yeah. Only against the bridge, right?
Correct.
Yeah, that's an amazing result. In the broken chair case, my client did have several back surgeries. He missed about 4 years of work, was able to get back working as a truck driver after those 4 years. That was a $1.25 million verdict, so not as big as yours. But yeah, I think both of us work in both those cases. I'm pretty proud of the work we did on both.
Oh, absolutely. And of course, excited and thrilled for the clients to finally get that closure and to get that compensation that they deserve. And that, by the way, it doesn't make it worth it, what they've been through.
No, it doesn't. But honestly, and more than the money, and both those cases are now on appeal, it's being given justice. It's the look on your client's face in particular afterward of, it was part relief. It was certainly part sadness. It was part happiness. It was a range of emotions, but it was really just the notion that we had gone in and we had told her story the best way we could. That process, I think, was really good for her.
Yes.
Yeah. So, all right. So we're going to end today something a little different. I got a trivia question for you, Jacob.
Oh, boy. Okay. All right.
So Who is the only member of the Senate Judiciary Committee who has ever achieved a verdict on behalf of an injured person against a hospital?
Oh boy. Senate Judiciary Committee plaintiff's lawyer. I don't know.
From South Carolina, Lindsey Graham. Lindsey Graham from the state of South Carolina, as conservative a Republican as you will find, is the answer to that trivia question. We were going to have him on today. Our apologies to Senator Lindsey Graham. We ran out of time. But that does it for Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Jacob Lawrence, Dan Grimm, and all of us at Cook, Barquette, Ponder, and Wolves, I'm Matt Glenn. We'll see you in 1 week.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.